Okay, good day everyone. My lecture is on special proceeding, last minute tips, praying that it will assist all our bar candidates and bar takers. Okay. Let's go to subject matter and applicability of general rules on special proceedings. Remember the definition of special proceeding. It is not a special civil action. It is not an ordinary action. It is a special proceeding. So it is an application to establish the SRP. What's SRP? The status. R is for the right of a party. P is for a particular fact, no? Or any remedy other than an ordinary suit in a court of justice, no? It only seeks to establish the status, the right of a party, or a particular fact, or any other remedy other than ordinary suit in a court of justice. So how do you distinguish a civil action from special proceedings? As I've said, it's SRP, no, ang special proceedings. But a civil action is one by which a party sues another for enforcement or protection of a right or prevention or redress of a wrong. Secondly, a special proceeding is generally commenced by application, usually by way of petition, no? As may provided, or special form of pleading as may be provided for by the particular rule or law. You know that insofar as ordinary action, it is commenced by way of a complaint. Third, you know that in an ordinary action, no, kailangan meron kang, you need to have a state to state a cause of action, no? Yung plaintiff has an existing right and it was violated by the defendant, and consequently the plaintiff suffered injury. Here in special proceedings, it does not pray for any affirmative relief for injury arising from a party's wrongful act or omission. Why? Because it's only seeks to establish again SRP, status, right, or a particular fact. Okay, having stated the differences between these two, the question is, are the rules in civil actions applicable in special proceedings, despite their differences? Rule 72, Section 2 is explicit in saying that in the absence of special provisions, the rules provided for in ordinary actions shall be, as far as practicable, applicable in special proceedings. So lahat ng mga amendments, no, sa rules of procedure, no, is applicable also in special proceedings, for as long as it does not conflict with any provision of special proceedings, then it is applicable. As stated in Shecker and Shecker, sabi dito is that the provisions of the rules of court requiring certificate of non-form shopping for complaints, initiatory pleadings, written explanation, payment of docket fees will not in any way obstruct probate proceedings. So all of these things under the provisions of an ordinary action in the rules of court, no, are applicable to special proceedings, such as in this case, yung settlement of the estate of a deceased person. As I mentioned before, pati mga modes of discovery, including the revision in the civil procedure, they're applicable to special proceedings for as long as walang conflict with any provision, no, of therein. Settlement of the estate of deceased person. Which court has jurisdiction over probate proceedings? So anong court ang may jurisdiction sa probate proceedings? Now, we know that there is an amendment to it, but pursuant to RA 7691, the question as to which court shall exercise jurisdiction over probate proceedings depends upon the gross value of the estate left by the decedent. Depends on the gross value of the estate of the decedent. In Metro Manila, this was before, no? Okay. But with the enactment of RA 1157-6, an act expanding the jurisdiction of the MTC, no? We have now this rule. What determines the jurisdiction of the RTC in probate proceedings? Section 1 amended Section 19 of BP 129. It provides that, number 4, jurisdiction of the RTC, no? In all matters of probate, both testate and intestate, where the gross value of the estate exceeds 2 million pesos. So that's the RTC, no? Exceeding 2 million pesos. So pababa niyan will be the MTC. Ayan. Jurisdiction of the MTC. So as I've said, pababa nun is the MTC. So exclusive original jurisdiction over civil actions and probate proceedings, testate or intestate, including the grant of provisional remedies in proper cases where the value of the property of the estate does not exceed 2 million pesos. Does not exceed 2 million pesos sa MTC. What about venue in the settlement of estate proceedings? The residence, venue, kanina, depending on the gross value of left by the decedent doon sa jurisdiction. No? 2 million is the point to consider. No? Exceeding 2 million, RTC. Below that, 2 million and less, MTC. Now, insofar as venue is concerned, the residence of the decedent at the time of his death. No? What determines venue of the proceedings? The residence of the decedent at the time of his death. Question, is that an absolute rule? There's one exception. Exception is, it is only where the decedent was, if he's a non-resident of the Philippines at the time of his death, no, that venue lies in any province in which he had an estate. Non-resident of the Philippines at the time of death, then venue lies in any province in which he had estate. Other than that, we follow the general rule. No, it's the residence of the decedent at the time of his death. What is the nature of the proceedings of the settlement of the estate? The settlement of a decedent's estate is, we deem it as a proceeding in rem. So since it's a proceeding in rem, it is binding against the whole world. So all persons having interest in the subject matter involved, whether they were notified or not, are equally bound. That's the general rule. What to talk about, sabi natin kanina, residence, no, venue, no, is determined by the residence of the decedent at the time of birth, at the time of his death. When you talk about residence, does it include domicile? No, because as that's defined, residence in the context of venue provisions, according to this case, no, it means nothing more than a person's actual residence or place of abode, provided he resides therein with continuity and consistency. Summary settlement of the estate, kasama ito, no? Of course, when a person dies, the rule is it should be judicially administered. That's a general rule. Pag namatay isang tao, it should be judicially administered. The exception is kung meron mang the execution of an extrajudicial settlement. No? Or number 2, if he's a sole heir lang siya, he will just execute an affidavit of being a sole heir. Now let's talk about extrajudicial settlement. When does it apply? No, not in all cases. Ang extrajudicial settlement nag-a-apply lang, number 1, if there is no will. No, walang iniwang will yung decedent. Pangalawa, no debts, wala silang utang. Third is that the heirs are properly represented. Even if they are minors, then they're still properly represented. And it should be executed in a public instrument, no, and registered in the registry of deeds. No. Now, halimbawa, nagkaroon, if there was an execution of extrajudicial settlement among the heirs, but one of there is left out. No, he had no knowledge or had not participated in the execution thereof. No, is the rule of constructive notice of publication binding upon him? So since there's notice na, binding na sa yon. Mag-a-apply ba yon? Constructive notice of publication insofar as extrajudicial settlement is concerned, particularly for persons who had no knowledge or had not participated in the execution thereof. The law is very explicit, no? Section 1 of Rule 74 says that publication in this case does not constitute constructive notice, no? Persons who do not participate or who had no notice of an extrajudicial settlement will not be bound thereby. Lumabas sa bar exam ito, maaring lumabas ulit ito. The publication of the settlement does not constitute constructive notice to the heirs who had no knowledge or did not take part in it because the same was noticed after the fact of execution. Notice after the fact of execution. Nag-execute mo sila, saka binigay yung notice. Hindi yung, ay, teka muna, na-notify namin kasi mag-execute kami. So, hindi, the constructive notice will not be applicable herein. I just included Rule 75 just to have a view of what is, again, to review of what probate is. Is allowance of a will necessary? 75. Rule 75, Section 1 provides that no will shall pass either real or personal estate unless it is probated or proved and allowed in the proper court. Is a probate of a will mandatory according to the rule that we've just stated a while ago? Yes, it is. No? Does a will have a force and effect even if not probated? No, until admitted to probate, a will has no effect and nobody can claim a right thereunder. So to give force and effect to the will, then it should be probated. Sayang, no? Sayang kung hindi probated, walang karapatang makukuha doon. May a probate court pass upon the intrinsic validity of the will. Kasi ang probate court can only pass as a general rule on the extrinsic validity of the will. Ano ibig sabihin ng extrinsic validity of the will? That the will has, number one, that the will was executed in accordance with the strict formalities of the law. Second is that the testator is of sound and disposing mind at the time that he executed the will. Third is that there was no duress or undue influence exerted against him. Lastly, it's that the genuineness of the signature of the testator. So if a will has been probated, you cannot, nobody can file a case to say that the signature of the testator is fake, or that the testator is not of sound on disposing mind, because again, when it is probated, it is conclusive as to its due execution. Conclusive doon sa extrinsic validity of the will, but not intrinsic. So the question is, can a probate court also pass upon the intrinsic validity of the will? Rule is that no, because in a special proceeding for the probate of a will, the issue and by and large is restricted, as I mentioned, to only extrinsic validity of the will. Whether the testator, being of sound mind, freely executed the will in accordance with the formalities prescribed by law. So as a rule, if there's a question of ownership, it's not an extrinsic, it does not refer to extrinsic validity of the will. It's intrinsic already. So as a rule, the question of ownership is an extraneous matter which the probate court cannot resolve with finality. That's the general rule. No? Is a probate court, unless the exception here is that all parties have given their consent, so that the probate court may pass upon the same. Is a probate court a court of limited jurisdiction? Yes, it is a court of limited jurisdiction. As such, it can only determine and rule upon issue that relate to settlement of the estate of deceased person. Katulad ng pag-administer ng property left by the decedent, pagbayad, liquidation ng mga utang, no, sa mga creditors ng estate, and what is left, the residue, is the distribution thereof. No? Allowance or disallowance of a will. Who may petition? Any executor, devotee, or legatee name in a will. Okay lang yun. Pero tingnan nyo, kahit na yung any other interested person may file the same. Kaya there's a question, sino ba tong person interested in the estate? No? According to this case, no, it defines who is an interested party. No, is one who will be benefited in the estate, such as an heir, or one who has a claim against the estate, such as a creditor. So a creditor may file also for the same, right? Question: is probate of a will subject to prescription? No, the probate of the will is not subject to statute of limitations and does not prescribe. Why? Because it can be filed anytime because it is required by public policy. It's a matter of public policy. So it is not subject to any prescription. Question: what is the nature of probate proceedings? As I've said, it is a proceeding in rem, no? Okay. What about lost or destroyed will? Pwede pa bang ma-probate yun? Or if a will has been lost or destroyed? Yes, no? In order that a lost or destroyed will may be allowed, the filing must be in a subsequent proceeding complied with. So if you're the lawyer for a particular person for probate of the will and the will had been lost or destroyed, still it can be probated for as long you can establish these three. Excuse me. Number one, execution and validity of the will must be established. Execution and validity of the will must be established. Second, you have to prove that the will must have been in existence at the time of the death of the testator. Nag-e-exist yung will at the time of his death, or shown to have been fraudulently or accidentally destroyed when during the lifetime of the testator, but without his knowledge or fault. And third, no, the provisions are clearly and distinctly proved by at least two credible witnesses. No, at least two credible witnesses. So this sums up those requirements to prove the lost or destroyed will. Claims against estate. What is the so-called statute of non-claims? It is the period fixed by Section 2 of Rule 86 for the filing of the claim against the estate. Under this, no, yung rule mandates certain creditors of a deceased person to present their claims for examination and allowance within a specified period, the purpose thereof being to settle the estate with dispatch, so that the residue, what remains, may be delivered to the persons entitled thereto, without their being afterwards called upon to respond in action for claims which under ordinary statute of limitations have not yet prescribed. Ang importante rito is the period within which the claim must be filed. No? The probate court is permitted by the rule to set the period as long as it is within the limitation provided. What is the limitation provided? It should not be less than 6 months, nor more than 12 months. Reckoned from when? From the day of the first publication of the notice thereof. Lumabas sa bar examination to, probably pwedeng ding lumabas, no? Not less than, it should be not less than 6 months nor more than 1 year or 12 months, reckon from when? The day of the first publication of the notice thereof. From the day of the first publication of the notice thereof. And such period already when fixed by the probate court now becomes mandatory. Remember this. What is the rationale in fixing the period to claim against the estate? The purpose of the law is to ensure a speedy settlement of the affairs of the deceased person and the early delivery of the property to the person entitled to the same. Question, is an extension of the given period allowed? Yes, it is clear from Section 2, Rule 86, that the period prescribed in the notice to the creditors is not actually exclusive. The money claim against the estate may be allowed at any time before an order of distribution is entered at the discretion of the court, and also for costs and upon such terms as are deemed equitable. What is the significance of publication of notice to creditors? The publication of the notice to creditors is constructed notice to all. No? Hence, a creditor cannot be permitted to file his claim beyond the period fixed in said notice on the background that he had no knowledge of the administration proceedings. So again, publication of the notice to creditors constitute as constructive notice. Ito, lumalabas sa bar to. Question, what are the three distinct alternative remedies available to mortgage creditor upon the death of the mortgagor? Three distinct alternative remedies available to a mortgage creditor upon the death of the mortgagor. What are these? The alternative remedies provided under this rule are the following. Number one, to waive the security mortgage and claim the entire debt from the estate as an ordinary claim. I-waive mo na yung security mortgage, doon ka na mag-concentrate doon sa sa estate, no? You claim the entire debt from the estate as an ordinary claim. What is the consequence for number one, yung pag-waive ng security mortgage? By filing money claim against the estate, he is now deemed to have abandoned the mortgage. And thereafter, he cannot file a foreclosure suit if he fails to recover his money claim against the estate. Wala na siyang mahahabol doon sa foreclosure or sa pag-waive ng sa security mortgage. Second, dito naman, hindi niya i-waive yung security mortgage. If foreclose niya, foreclose the mortgage judicially. And if there are deficiencies, then prove any deficiency as an ordinary claim. Now, the foreclosure suit, it should be against the executor or administrator as party defendant. Now, in the event that a creditor fails to fully recover his claim, okay lang yun. He may claim and obtain the deficiency judgment and file it as a claim against the estate. He can claim it in the estate. Third, to rely solely upon the mortgage and foreclose the same. At any time it is before it is barred by prescription. Now, without right to claim for any deficiency. Number three is to rely solely upon the mortgage and foreclose the same at any time before it is barred by the prescription without right to claim for any deficiency. This mode includes extrajudicial foreclosure of sale, and its exercise precludes one from recovery any balance of indebtedness against the estate and frees the estate from further liability. Lumalabas sa bar yan, ha? Okay. Now we know this. General rule, probate court has no jurisdiction to entertain a claim in favor of the estate against a third person. So estate against a third person. Bakit? Kasi that should be the subject of an ordinary action. Will there be an exception to this rule? Do sa third party, no? The exception to this rule is provided under Section 10 of Rule 86. It authorizes the executor or administrator to interpose any counterclaim in offset of a claim against the state. No? Such counterclaim is regarded as a compulsory counterclaim, as the failure to file the same shall bar the claim forever. So pwede against third person if it is in the form of a compulsory counterclaim. Payment Rule 88, payment of the debts of the estate. Kasama ito sa syllabus in special proceedings. Question, does the probate court have the power to issue a writ of execution to pay claims? As a general rule, no. Probate court cannot issue a writ of execution. No? As held in this case, a writ of execution is not the proper procedure allowed by the rules of court for the payment of debts and expenses of administration. What is the proper procedure? Ang proper procedure is for the court to order the sale of personal estate. No? Doon ka, no? You ask the court to order the sale of the personal estate or the sale or mortgage of real property of the deceased. And all debts and expenses of the administration should be paid out of the proceeds of itong sale or mortgage. No? The order for the sale or mortgage should be issued upon motion. Pag-file ng motion ng administrator, no? And with the written notice to all the heirs, kailangan na-follow nila yung notices, no, to the heirs, legatees, devisees, according to Section 3 of this rule and Section 2 of Rule 89. And when the mortgage or sale is to be made, the regulations contained in maigpit sila sa ganito, no? In Section 7 of Rule 89 should be complied with. We will discuss that. Are there exceptions? Yes. In 3 instances, the probate court may issue writs of execution. Memorize these 3. Number 1, to satisfy the distributive shares. Satisfy the distributive shares of the devisees, legatees, and heirs in possession of the decedent's assets. Number 2, no? I can also issue writ of execution to enforce payment of the expenses of partition. Lastly, the probate court can issue also writs of execution to satisfy the cost when a person is cited for examination in probate proceedings. Question, may the court authorize any persons to dispose of the properties of the estate? Can the court authorize any person to dispose of the properties of the estate? It is only the executor or administrator of the estate whom the court may authorize to dispose of the properties of the estate, so that the proceeds of the sale or mortgage may be applied to any obligations that the estate has. So, the rule is that the executor or administrator lang. Is an heir or distributee liable for outstanding claims against the estate? Liable ba ang heir or distributee for outstanding claims against the estate? According to this jurisprudence, no, heirs are not required to respond with their own property for the debts of their deceased ancestors. But even after the partition of the estate, the heirs and distributees are liable individually for the payment of all lawful claims against the estate. No? But in proportion to the amount or value of the property they have respectively received from the estate. Hindi pwedeng lumagpas doon sa property received, no, from the estate. The hereditary property consists only of that part which remains after the settlement of all the lawful claims against the estate. For the settlement of the entire estate is first liable. The heirs cannot, by any act of their own or by agreement among themselves, reduce the creditor's security for the payment of their claims. Kasi nga, when we talk about settlement of the estate, no, kailangan magkaroon mo ng administrator, i-collate lahat ng properties ng estate. Ito yan. No? After that, no, you manage that, you administer, then you pay all the debts, the obligations to the creditors, etc. And what remains is na kung anong natira is the distribution already to the heirs. Hindi pa pwedeng yung mga heirs to deprive or reduce the creditor security for the payment of their claims. No. What may the court do if a contingent file is claimed? Kung may contingent file is claimed, anong dapat gawin? The court may order that sufficient estate be retained to pay the contingent claim. Pwede mag-order ang court, no, na yung merong portion ng estate i-retain para kung sakali man bayaran ang contingent claim. Okay? Yon. What is the consequence if such a contingent claim becomes absolute and is presented within 2 years from the time limited for other creditors to present their claims? The contingent may be allowed by the court if not disputed by the executor or administrator. But if disputed, it may be proved and allowed or disallowed by the court. Bahala na si court or si judge. Rule 89, kasama sales syllabus. No? So we have to discuss this. Sales, mortgages, and other encumbrances. These are very important notices. No? Are the notices under sections 2, 4, and 7 of Rule 89 a mandatory requirement to affect the authority of the sale or encumbrance of real property? Yes. Failure to give notice to the heirs, devisees, or legatees would invalidate the authority granted by the court. So sabi dito, without compliance with these sections, sections 2, 4, and 7 of Rule 89 of the Rules of Court, the authority to sell, the sale itself, and the order approving it would be null and void ab initio. No? So kailangan mag-follow sila sa sections 2, 4, and 7 of Rule 89. Pwedeng itanong sa bar exams to. O ano ba itong sections 2, 4, and 7 under Rule 89? Where notices are deemed mandatory. No? The requirement of written notices under Rule 89 of the Rules of Court are mandatory, and failure to give notice to the heirs would invalidate the authority granted by the intestate or probate court to mortgage or sell estate assets. Section 2. No? When court may authorize sale, mortgage, or other encumbrance of realty to pay debts and legacies through personality not exhausted. Iyon. So nakalagay dito, tingnan nyo, written notice to the heirs, devisees, and legatees residing in the Philippines. When the personal estate of the deceased is not sufficient to pay the debts, expenses, and administration legacies, or where the sale of such personal estate may injure the business or other interests of those interested in the estate, and where a testator has not otherwise made sufficient provision for the payment of such debts, expenses, and legacies, the court, on the application of either the executor or administrator, and written notices to the heirs, devisees, and legatees, may authorize the same. No? Ganun din sa section 4. No? When court may authorize sale of estate as beneficial to interested persons. When it appears that the sale of the whole or a part of the real or personal estate will be beneficial to all the heirs, devisees, legatees, and other interested persons, the court, again, application ng administrator, pero kailangan may written notices. Kanino? Heirs, devisees, legatees, or those interested in the estate. No? So pag-fix ng court ng time and place for hearing, kailangan meron ding notice of stating the nature of the petition, okay, and reasons for the same, and time and place, okay, to be given to these persons. No? Yon. So sections 2, 4, and 7 must be complied with. Kaya nga, in this case, kay pahumutang, settled is the rule in this jurisdiction that when an order authorizing the sale or encumbrance of real property was issued by the testate on intestate court, but without previous notice to the heirs, devisees, and legatees. Sabi dito, it is not only the contract itself which is null and void, pati yung order of the court authorizing the same. It emphasized by saying that without compliance with sections 2, 4, and 7 of Rule 89, the authority to sell, the sale itself, and the order approving it will be null and void ab initio. Ano mga void? Authority to sell, the sale itself, and the order approving it will be null and void ab initio. Remember this. This may be asked. Clearly, the requirements of Rule 89 are mandatory, and failure to give notice to the heirs would invalidate the authority granted by the intestate probate court to mortgage or sell estate assets. Rule 90, this is the last in the settlement of the estate of deceased person, the last rule. When must the order for distribution of residue be made? Yung what remains, no? When the debts, utang, funeral charges, expenses of administration, o yung allowance sa widow, inheritance tax, no? If any, chargeable sa estate, bayaran muna yan, no? At pag may sobra, no, the court shall assign the residue of the estate to persons entitled to the same, naming them and the proportions or parts to which each is entitled. It also provides that no distribution shall be allowed until the payment of the obligations above mentioned has been made. Hindi pwedeng i-distribute kung hindi pa binabayaran yung mga yon. Unless kung gusto nila, no, give a bond in a sum to be fixed by the court. And that bond is conditioned for the payment of said obligations within such time as the court directs. What is liquidation? It means the determination of all the assets of the estate and payment of all debts and expense. Ganun lang kasimple yung liquidation. What about if there is an advancement? There was an advancement made by the decedent already. May the court hear and determine questions as to the advancement, no, made by the decedent? Yes. Questions to advancement made or alleged to have been made by the deceased to any heir, no? Nabigyan niya na muna yung mana, no? It can be heard and determined by the court having jurisdiction of the estate, no? And the final order of the court thereon shall be binding on the person raising the questions and on the heir. So in this case, the issue is whether or not the properties in question subject of a deed of donation. Hindi sale yan, donation, ibinigay, hindi binenta, no? Deed of donation during inter vivos executed by the decedent during his lifetime should be excluded daw from inventory of the estate of deceased. So that's the issue, no? Sabi ito, hindi. It bears stressing that the question is one of collation or advancement by the decedent to an heir over which the question of title and ownership can be passed upon by a probate court. So in this case, ang pangalan yung claim ng part ng person of ownership over the disputed lot rests upon the deed of donation executed by his father, who is the decedent, and his mother. Article 1061 of the Civil Code is applicable in this case, that every compulsory heir who succeeds with each other compulsory heirs must bring muna, collate into the mass of the estate any property or right which he may receive from the decedent during the lifetime of the latter by way of donation, or any gratuitous title, in order that it may be computed in the determination of the legitim of each heir in the account of partition. So kailangan i-collate. in relation to which also Section 2 of Rule 90 is applicable, that questions as to advancement made are already made that by express provision of the law, this disputed lot which was alleged to have been donated by the decedent and his wife to their son, respondent Vicente, should not be excluded from the inventory of the properties of the decedent. Meaning to say, isama mo siya sa pagbilang as estate. Question. Sir, what is the effect of final decree of distribution? A final decree of distribution of the estate of a deceased person vests the title to the land of the estate in the distributees. No? So where the court has validly issued a decree of distribution na, and the same has become final, the validity or invalidity of the project of partition becomes irrelevant. So the question, when does a probate court lose jurisdiction of an estate under administration? Okay, the probate court lose jurisdiction of an estate under administration only after, again, payment of the debts and the remaining estate delivered to the heirs entitled to receive the same. And the final approval, the finality of the approval of the project of partition by itself alone does not terminate the proceeding. So kung merong mang approval of the project of partition at ito yung naging final, it will still not terminate the proceeding. No? Probate court still has jurisdiction for as long, sabi ng court, for as long as the order of the distribution of the estate has not been complied with, the probate proceedings cannot be deemed closed and terminated. So as long there should be the order of distribution of the estate, which must be complied. Okay, let's go to a different topic in special proceedings, which is Rule 91, Escheat. This is included. No? You know this already. What is the concept of escheat? It is a proceeding whereby the real and personal property of a deceased person would now become the property of the state. When? Kailan? Upon his death, without leaving a will or legal heirs. So wala siyang will, wala siyang tagapagmana. It will now become the property of the state upon his death. So it is not an ordinary action, but a special proceeding, commenced by way of petition and not by a complaint. Venue, in so far as escheat is concerned, a petition to declare as escheated a parcel of land owned by a resident of the Philippines who died intestate without heirs or persons entitled to the property is to be filed where at the place where the deceased person last resided. At the place where the deceased person last resided. So it's similar to that of the settlement of the estate of deceased person. Should be filed at the place where the deceased person last resided. Is there an exception? Later on, we will discuss that. Even if the decedent died testate, question. Escheat is proper when there is no will left by the decedent. Could there be an instance where an escheat proceeding is proper even if the decedent died with a will? Yeah, there's a case. So even if he died with a will or testate, but unfortunately, the will was not probator or is not allowed to probate, what is the consequence? You know this. It is as if he died intestate. So if that being the case, if he has no known heirs and there are no persons entitled to his property, the same can be escheated. Yeah. So lumabas sa bar on venue, a petition to declare as escheated a parcel of land by resident of the Philippines who died intestate without such and such. No? The place where the deceased person last resided. What is the consequence if the claim of the escheat property is with after the lapse of the 5-year period? There's a 5-year period reckoned from the entry of the judgment, no, of escheat, escheat judgment, no. So entry of the escheat judgment, pwede silang mag-file still, no, a claim thereon within 5 years, reckon from such date. 5 taon lang. So the right to claim the property is lost and the escheat judgment can no longer be nullified if it is beyond the lapse of the 5-year period reckoned from when? The entry of the escheat judgment, no? Now, in one case, sabi ng court, lumagpas, no? Na-discover lang yung deeds of the nation, kanya pala yon. Kaya lang beyond the 5 years, sayang naman, no? With the lapse of the 5-year period, therefore, private respondent has irretrievably lost her right to claim, and the supposed discovery of the deeds of the nation is not enough justification to nullify the escheat judgment which has long attained finality. Yan, lumabas sa bar, no? So suppose the property was declared escheated on July 1st, 1990. This was in 2002 bar. So the date is 1990, so 12 years ang naglapse, no? The action is not viable anymore, okay? Because naglapse na and it is beyond the 5 years period, no? In this case, the property which has been escheated in favor of the government since July 1st, 1990, no? The claim is beyond the time limitation allowed by law. That was asked in 2002, so 12 years had lapsed since the escheat judgment. Guardianship. As provided under the rules of court, Rules 92 to 97 of the Rules of Court limits its application only to guardianship of incompetence. Guardianship of incompetence under Rules 92 to 97. Guardianship over minors governed by Administrative Circular Number 03-02-05. Okay, and this admin circular is known as the Rule on Guardianship of Minors. The Rule on Guardianship of Minors. Yan. Which court has jurisdiction over guardianship proceedings? I-determine mo muna yon. Guardianship over incompetence or guardianship over minors? In guardianship proceedings involving incompetence who are not minors, the RTC where he resides has jurisdiction pursuant to the provision of BP 129, no? And in guardianship of minors, where the minor sites. So in other words, venue is the place of residence kung in either way, kung guardianship over minors, kung saan nakatira yung minor. Yung incompetent, kung saan nakatira incompetent person. No. This is always the exception, no? It's always the exception. Kung yung minor or incompetent resides outside the Philippines, no, the petition may be filed in the RTC of the place where the property of such minor or incompetent may be situated. That goes well also with the escheat proceedings. If the person is a resident of the outside the Philippines, then it will be filed where the property is located. Venue. What is guardianship? No, let's define what guardianship is all about. It is a trust relation of the most sacred character, in which one person called a guardian acts for another called the ward, whom the law regards as incapable of managing his own affairs. So a guardianship is designed to further the ward's well-being, not that of the guardian. It is intended to preserve the ward's property, as well as to render any assistance that the ward may personally require. So the basis of guardianship is parens patriae. The duty of the state protecting the rights of persons or individuals who, because of age or incapacity, are in an unfavorable position vis-a-vis other parties. Define a guardian is he is a person in whom the law has entrusted the custody and control of the person or estate or both of an infant, insane, or other person incapable of managing his own affairs. So we have the general guardian, limited guardian. Pag limited lang, over the property. General guardian, over the person of the ward or over his property. Legal guardian, katulad ng mga parents, they are persons without need of judicial appointment, designated as such by the provision of the law. No? Like in the case of parents, over the persons of their minor children. Who is a guardian ad litem? Any incompetent person appointed by the court. What? To prosecute or defend a minor. Insane or person declared to be incompetent in an action in court. That is a guardian ad litem. Which court has jurisdiction? It is those incompetents. It is the RTC. No, where the minor resides. In guardianship minors, it is the family court where the minor resides, especially designated as such. We have discussed this already. So there was a question in the bar exam as to venue. Yeah. A petition for the appointment of an administrator over the land and building left by an American citizen residing in California who had been declared incompetent by an American court. Give the proper venue. A petition for the appointment of an administrator over the land and building left by an American citizen residing in California who had been declared incompetent by an American court is the RTC of the place where his property or part thereof is situated, because he is a non-resident of the Philippines. 93. Appointment of guardians. In appointing a guardian, these are the factors that the court should consider. Baka pa niya may taning na yung buhay ng guardian eh. Paano niyo pa maalagaan yung ward? Di ba? So, factors taken into consideration of a suitable guardian. Tingnan niyo yung financial situation. Baka naghihikaws lang yan, di ba? The physical condition, kaya niya pa bang mag-alaga, maging guardian? Sound judgment, prudence, and trustworthiness. His moral character and conduct, and the present and past history of this prospective appointee, as well as the probability of his being able to exercise the powers and duties of guardian for the full period during which guardianship is necessary. Kung abroad naman siya, kaya niya bang gawin yun? Of course, hindi. Now, once you're appointed as a guardian, what are your general powers and duties? No? Number one, have the care and custody of the person of the ward. I-manage mo yung estate niya. Or both, or just the management of his estate only. You pay the debts of the wards. No, if you settle accounts, collect debts, appear in actions for the ward. Of course, you have to manage the estate frugally, no, and apply the proceeds to the maintenance of the ward. Now, once you are appointed, no, you need to render verified inventory within 3 months. Inventory within 3 months, record from the day of appointment. And then after that, yearly or annually thereafter. And lastly, must present his account to the court for settlement and allowance. Remember these powers, and duties. In appointing a guardian, just like in adoption cases, or custody cases, the court is always governed by this principle, which is the best interest of the child. The principle of the best interest of the child pervades Philippine cases involving adoption, guardianship, as we're discussing, support, personal status, minors in conflict with the law, and child custody. The court said that in these cases, it has long been recognized that in choosing the parent to whom custody is given, the court should consider this. The welfare of the minor should always be the paramount consideration. The welfare of the minors should always be the paramount consideration. Courts are mandated to take into account all relevant circumstances that would have a bearing on the children's well-being and development. Also, aside from the material resources and the moral and social situation of each parent, other factors may also be considered to ascertain which one has the capability to attend to the physical, educational, social, and even moral welfare of the children. So among these factors are the previous care and devotion shown by each of the parents, their religious background, moral uprightness, home development, and time availability, as well as the children's emotional and educational needs. Aside from the best interest of the child, principle, we also have this tender age presumption. Tender age presumption. There is an express statutory recognition that as a general rule, a mother is to be preferred in awarding custody of children. The caveat in Article 213 of the Family Code cannot be ignored except when the court finds cause to order otherwise. The so-called tender age presumption under 213 of the Family Code may be overcome only by compelling evidence of the mother's unfitness. So if you are the counsel for the father, and you've got to overcome that tender age presumption. How do you do it? By compelling evidence of the mother's unfitness. So the mother has been declared unsuitable to have custody of her children for neglect, abandonment, unemployment, immorality, habitual drunkenness, drug addiction, maltreatment of the children, insanity, or affliction with a communicable disease. But the court said that in this case, that sexual preference or moral laxity alone does not prove parental neglect or incompetence, or not even the fact that a mother is a prostitute or has been unfaithful to her husband would render her unfit to have custody of her minor child. To deprive the wife of custody, the husband must clearly establish that her moral lapses have had an adverse effect on the welfare of the child or have distracted the offending spouse from exercising proper parental care. Let's go to the rule on guardianship of minors. There's an order of preference in appointing the same. The order of preference shall be as follows. Surviving grandparent. And in case several grandparents survive, the court shall select any of them. Basta bahala na si court, taking into account all relevant considerations. Next in line in the order of preference is the oldest brother or sister of the minor. Not everyone. Kailangan over 21 years of age. And unless unfit or disqualified, even if they're of age. Third, in the order of preference, the actual custodian of the minor, for as long as, again, over 21. But even if over 21 pero unfit or disqualified, they cannot. Or lastly is any other person who in the sound discretion of the court would serve the best interest of the minor. Again, the best interest principle is applied in the order of preference. Okay, let's go to habeas corpus. Habeas corpus. Cases where habeas corpus is extended. Under section 1, nakalagay dito, the writ of habeas corpus shall extend to all cases of illegal confinement or detention by which any person is deprived of his liberty. That's one, do not interchange the application of writ of amparo, no, or habeas data from that of habeas corpus. Kasi ang habeas corpus, no, you would know that there's no enforced disappearance, no, and you know where the whereabouts of that person, but he was illegally confined or detained. So number one, in case of deprivation of liberty, in all cases of illegal confinement or detention by which any person is deprived of his liberty, that's only number one. Pwede rin ng habeas corpus by which where the issue is the rightful custody of any person. Rightful custody of any person is withheld from the person entitled thereto. Oh, minors, no? Pwede yun. Rightful custody over the minor. Pwede rin yung minsan pinag-awayan custody ng nanay, no, ng nilola, no? That's also an issue. O may isang kaso, si wife, mahal na mahal niya si husband. Presumably, mahal niya si husband, no? She, or just because mayaman si husband, no? Can she secure a writ of habeas corpus to compelling her husband to live with her in conjugal bliss? So wala sa kanya si husband. Actually, dun sa isang anak niya, no? Magkalaban sila. But the wife filed a writ of habeas corpus to compel her husband to live with her in the conjugal bliss. The question is, will this be granted or not? No, it's not. I'm sorry, no. Marital rights at the court, including coverture and living in conjugal dwelling, may not be enforced by the extraordinary writ of habeas corpus, no. A writ of habeas corpus is applicable again to illegal confinement or rightful custody. But the court said that no court is empowered as a judicial authority to compel a husband to live with his wife. Coverture cannot be enforced by compulsion of a writ of habeas corpus. Sabi ng Supreme Court, I'm sorry. Because this is a matter beyond judicial authority and is best left to the man and woman's free choice. So this is Illusoria versus Bildner. The court went on to continue that to justify the grant of the petition, dapat yung restraint of liberty must be an illegal and involuntary deprivation of freedom of action. Hindi siya, illegal restraint must not be moral or nominal, but it must be an actual and effective illegal restraint of liberty. So kung hindi pa pwede yung writ, baka naman visitation rights. Okay? Kung ayaw, nag-file si wifey ng okay, hindi pwedeng just to return to the conjugal dwelling, perhaps I can visit you. Oh, di ba? But if the husband, say for example, refuses to see his wife, pwede bang i-cite for contempt siya ng court? Hoy, kailangan i-meet mo yung si wifey mo. Okay? In case the husband refuses to see his wife for private reasons, I'm sorry, wifey, he is at liberty to do so without threat of any penalty attached to the exercise of his right. What right is that? To refuse to see his wife for any reasons. When the court, the lower court, the CA ordered the grant of visitation, nilagay din, it also emphasized that the same shall be enforced under the penalty of contempt. No, sa lower court, sa CA, sabi, oy, granted ng visitation, kailangan you have to see your wife, otherwise you'll be under the penalty of contempt in case you refuse to comply. But the Supreme Court said such assertion of raw naked power is unnecessary. Why? Court explained in the case at bar, the Court of Appeals missed the fact that the case did not involve the right of a parent to visit a minor child. No, hindi ito involving the parent visiting a minor child, but the wifey to visit her husband. Eh kung ayaw ni husband, I'm sorry, in case the husband refuses to see his wife for private reasons, he is at liberty to do so without threat of any penalty attached to the exercise of his right. Are there any instances where a writ of habeas corpus may be issued even if the detention is by virtue of a judgment? Because the rule is no. If a person is convicted and he is detained because there is a final judgment of conviction, so the deprivation of liberty is not unlawful, it's lawful. So this will not lie, right? But there are cases where habeas corpus may still be availed of, despite the fact that there is a final judgment of conviction. In this case, the writ may be allowed, as we call it, as post-conviction remedy. Remember that, post-conviction remedy. When the proceedings leading to the conviction were attended by any of the following, what we call as exceptional circumstances. So pwede yun, ang habeas corpus as a post-conviction remedy for as long these exceptional circumstances are present. Number one, there was deprivation of a constitutional right resulting in the restraint of a person. O kaya yung court na yon had no jurisdiction to impose the sentence. Or number three, the imposed penalty was excessive. Thus, you void the sentence as to such excess. Eh kung iyon ay dapat jurisdiction lang ng MTC, 'di ba? Ang nag-ano sa kanya ay RTC, The court had no jurisdiction to impose the same. Or the imposed penalty was excessive, i-void mo yung excess. Question, may habeas corpus be resorted to where rightful custody is withheld from a person entitled thereto? As we mentioned a while ago, yes, pwede. That's the second part of habeas corpus, deprivation of liberty, then determination of the rightful custody of a person. Habeas corpus may be resorted to in cases where rightful custody is withheld from a person entitled thereto under Article 211 of the Family Code. Do you need to file a motion for execution to effect habeas corpus decision? Lumabas sa bar dati ito. No, there is no need to file a motion for execution for habeas corpus decision. Why? Since the right to life, liberty, and security of a person is at stake. The proceeding should not be delayed, and execution of any decision thereon must be expedited as soon as possible, since any form of delay may jeopardize the very rights these writs seek to immediately protect. Tatagal lang eh. Now we have this, admin number 03-04-04, kasama sa syllabus niya yan. The rule on custody of minors and writ of habeas corpus in relation to custody of minors. So may latest case dyan. What are the requisites for the grant of the writ of habeas corpus involving custody of minors? These are the requisites. Number one, if you're the counsel of a party claiming that the rightful custody over a minor is withheld from him, what must you do? Assuming you're the client for the father, you're the lawyer for the client father. Number one, you have to prove as a lawyer that the petitioner has the right of custody over the minor child. Tatay siya, Second, the rightful custody over the minor is being withheld by the respondent. Wala sa kanya, nandun sa mother. Number three, it serves the best interest of the minor child to be in the custody of the petitioner rather than with the respondent. Again, applying this best interest of the minor in habeas corpus involving minors. So it's actually the court is mandated to determine the best interest of the minor in awarding custody over which party? Is it the father or is it the mother? This is the latest case. No? In habeas corpus involving custody of minors, must the question of illegal and involuntary restraint of liberty be the underlying rationale for availability of the writ as a remedy? So ang case is not simple, habeas corpus, but peculiar only, habeas corpus involving custody of minors. Ang isipin ba ng court is that of illegal involuntary restraint, no? Would that be the underlying rationale for the availability of the writ as a remedy? No, said the court. No, it's not. The question of illegal and involuntary restraint of liberty is not the underlying rationale for the availability of the writ as a remedy. Ganun ba, sir? Yes. Kasi involving minors to eh. The writ of habeas corpus is prosecuted for the purpose of determining, again, the right of custody over a child. The court went on to explain, this is a 2020 decision. These cases are decided not on the legal right of the petitioner to be relieved from unlawful imprisonment or detention, as in the case of adults. Magkaiba to. But on the court's view of the best interest of those whose welfare requires that they be in the custody of one person or another. Hence, the court is not bound to deliver a child into the custody of any claimant or of any person, but should, in the consideration of the fact, leave it in such custody as its welfare at the time appears to be required. In short, pag habeas corpus in relation to custody of minors, the child's welfare is the supreme consideration. Hindi lang, ay, na-deprive siya ito. Ay, hindi na-deprive. Teka, sabi ng court. Hindi yan. Welfare ng bata muna. No? Bago sa inyo. Saan ba mas ang pinaka-best interest ng bata? Dito sa party na to o dito sa kabila? Okay? Before this, we will, sige, after the writ of amparo, then we will have a break. The writ of amparo is intended to address the violations or threats to the right, liberty, or security as an extraordinary and independent remedy beyond those available under the prevailing rules or as a remedy supplemental to these rules. So, question, to what cases are the writ of amparo applicable? The remedy of amparo in its present formulation is confined merely to instances of extralegal killings or enforced disappearances and to threats thereof. No? Extralegal killings, enforced disappearances, and to threats thereof. So do not, again, interchange, pwede na lang habeas corpus or amparo. No, you can choose, no. Kasi habeas corpus, as you know, it's only applicable to cases illegal deprivation of liberty and rightful custody. Insofar as amparo is concerned, it is confined merely to instances of extra-legal killings or enforced disappearances or threats thereof. No, notice that it does not use the word extrajudicial killings. Ang ginamit na term is extra-legal killings. So, meron bang definition? These are killings committed without due process of the law, without legal safeguards or judicial proceedings, much like that of extrajudicial. But enforced disappearances, there's no actual definition, but the court said that they are attended by the following characteristics: an arrest, detention, or abduction of a person. By whom? By private individual? No. By a government official. Pwede bang private? Yes. Organized groups or individuals, but no, not acting alone, but acting with the direct or indirect acquiescence of the government, no? The refusal of the state to disclose the fate or whereabouts of the person concerned, or a refusal to acknowledge the deprivation of liberty, which places such person outside the protection of the law. Memorize. I'm sure you memorize this. Just remember this, no? Pag sinabing enforced disappearance, ano yun? As I mentioned, arrest, detention, or abduction of any form or of deprivation of liberty, that it be carried out by with the authorization, support, or acquiescence of the state or political organization, that it be followed by the state or political organization's refusal to acknowledge or give information on the fate or whereabouts of the person subject to of the amparo petition. And lastly, that the intention for such refusal is to remove the subject person from the protection of the law for a prolonged period of time. Is government involvement in the disappearance an indispensable element? Yes. It may lie against a private individual or entity, but even if the person sought to be held accountable or responsible in an amparo petition is a private individual or entity, still government involvement in the disappearance remains to be an indispensable element. Remember that. Government involvement in the disappearance remains an indispensable element. Question: what is the secondary requirement imposed on state agents in writ of amparo? Kung meron mga state agents, what is the secondary requirement imposed upon them? So this was a 2021 case, no? The answer is Section 17 of the Rule on the Writ of Amparo requires both parties to the petition to establish their respective claims with substantial evidence. But apart from this, Section 17 also imposed a secondary requirement on state agents. What is that secondary requirement? They must show extraordinary diligence in the performance of their duties and are forbidden from seeking refuge. No, they cannot claim and hide under the presumption of regularity in the performance of their official duties. Okay, again, they must show extraordinary diligence in the performance of their duties, and they are forbidden from seeking refuge in that presumption of regularity of performance. So in these cases, just a brief rundown on it. There's a finding that the persons are liable on account of abject failure to conduct a fair and effective official investigation, office or deal in the hands of the military. Kaya kailangan nag-perform nga sila na extraordinary diligence, di ba? To find the whereabouts of the missing person. Abject failure to conduct a fair and effective official investigation. In this case of Rubrico versus Macapagal, the question is whether we will impose is the command responsibility applicable in writ of amparo? Sabi, yes, limited only, limited application. If command responsibility were to be invoked and applied to this proceeding, it should at most be only to determine the author, no, who is accountable, and the duty to address the disappearance and harassments complained of, no? Why? So to enable the court to devise remedial measures that may be appropriate under the premises to protect the rights covered by the amparo. However, no, you cannot apply command responsibility if the purpose is to fix criminal liability, no, on respondents preparatory to filing a criminal action, prosecution. You cannot fish evidence, no, with eventual desire to file a criminal action, no, or as a prelude to admin disciplinary proceedings, not also, no. Father Robert Reyes, the running priest, he was accused, one of the accused in the case in the Manila Peninsula siege, no, where there are military rebels, and a murder case was filed against him. Now, he would want that, and eventually there is a whole departure order that was issued against him. Now he would want that HDO order be withdrawn, no, by the BID. And to do that, no, nilagay niya by way of petition to for the issuance of writ of amparo, claiming that his right to travel had been impaired. Is this a proper issue in amparo? The court said no, because the restrictions in on petitioner's right to travel as a consequence of the pendency of the criminal case, which is murder, which is rebellion, was not unlawful. Petitioner also failed to establish that his right to travel was impaired in the manner and to the extent that it amounted to a serious violation of his right to life, liberty, and security, for which there exists no readily available legal recourse or remedy. Secretary of National Defense versus the Manalo brothers. These Manalo brothers were suspected of being members of the NPA, and they were apprehended together with their companions. Now, when they were under military detention, they were subject to physical abuse and torture, and some of their companions were even killed. Now, fortunately for these two, they were able to escape from detention, and consequently, they filed a petition for writ of amparo. Now, it was argued, if they are no longer under the military custody, they're not entitled anymore. That's already moot in academic. So that's an issue in this case. Sabi ng court, no, despite the fact that they're not in the detention of the military. But nonetheless, the circumstances respondents' abduction, detention, torture, and escape reasonably support that there is an apparent threat. Tandaan nyo, extralegal killings and forced disappearances, kasama yung threats doon. No? So there is again an apparent threat that they will be abducted, tortured, and even be killed, executed. This constitute threats to their liberty or security and life, actionable through a petition for a writ of amparo. Next. Kung last topic of homeowners, ang nakalagay lang dito na, again, if it is a threatened demolition of a dwelling by virtue of a final judgment of the court, it does not fall under extra legal killings or enforced disappearance, then the case is dismissible. As well as in this case, when the issue is just an exercise of parental rights over a child, no, that will not file under the writ of amparo. If it involves purely property or commercial right, again, not applicable because it does not involve extra legal killings or enforced disappearances or threats thereof. Okay? Okay. Writ of Habeas data. After this, then we'll have a break. The rule on the writ of Habeas data, admin number 08-1-16. Define writ of habeas corpus, habeas data under section 1. It provides that it is a remedy available to any person whose right to privacy in life, liberty, or security is violated or threatened by a lawful act or mission of a public official or employee. So the first part of the sentence involves public official or employee. But the second part of the sentence is this: of a private individual or entity, walang acquiescence of the government, direct or indirectly. So purely pwede ang private person. Or of a private individual or entity for as long as engaged in the gathering, collecting, GSS, gathering, collecting, or storing data or information, no, regarding what? The person, the family, home, and correspondence of the aggrieved party. The writ of habeas corpus in this case, said the court, that it directs the issuance only against public officials or employees. Okay lang yun. But the second part is private individuals or entities, again, engaged in the GCS, gathering, collecting, storing of data or information regarding an aggrieved party's persons, no? Including his family, including his home as well. In the landmark case of Vivares versus St. Teresa's College, these are the principles enunciated by the Supreme Court. The writ of the habeas data is not only confined to extra legal killings and enforced disappearances. Excuse me. It can also be availed of as an independent remedy to enforce one's right to privacy, more specifically, the right to informational privacy. Anong remedy, anong prayers na pwede mga nito i-seek, no, from the court? The remedies against the violation of such right include the updating, rectification, suppression, or destruction of the database or information or files in possession or in control of respondents. Pag private individual or company, no, entity, engage in the gathering or collecting storing of data information, does it mean engage in the business of collecting or storing data or information? Supreme Court said no. The individual or entity need not be in the business of collecting or storing data. Supreme Court had to occasion to explain the meaning of engage. It said that to engage in something is different from undertaking a business endeavor. And to engage means to do or take part in something. So it does not necessarily mean that the activity must be done in the pursuit of business. So that's one thing that they explain in this case. Also, no, specifically considering that the faults, kasi di ba naka-clad sila sa bikini, no, and as a classmate of these ladies, young ladies, no, reported the matter to the school, to their teacher. No, pinakita sa Facebook. Oh, this is posted by our classmates. No? So it reached the administrator, and they decided not to allow them to graduate. So the parents filed a petition for writ of habeas data. No, but it says there in the decision that the default setting for the Facebook post is public, meaning it can be surmised that the photographs in the questions were viewable to anyone, to everyone in Facebook, and absent of proof that petitioner's children positively limited the disclosure of the photograph. If such were the case, they cannot invoke the protection attached to the right to informational privacy. This is a latest case. Can a writ of habeas data be issued in favor of a convicted national inmate to enforce his right to privacy? So nag-file ng petition for habeas data, no? Yung in favor to issue a writ of habeas data in favor of not a private person, but a convicted national inmate to enforce his right to privacy. Pwede ba yun? Sabi ng court, unfortunately, no, for them, the right to privacy of those detained is subject to Section 4 of RA 7438, as well as to the limitations inherent in lawful detention or imprisonment. By the very fact of their detention, pretrial detainees and convicted prisoners have a diminished expectation of privacy rights. Again, no, yung pretrial detainees and convicted prisoners, the term used is diminished expectation of privacy rights. Exemplified in this 2020 case, no? Here said the court, the writ is being sought to compel the Department of Justice to produce documents to justify Boratong's transfer from the National Bilibid in Muntinlupa to the National Bilibid Prison Extension Facility in Manila City. This allegation bears no relation to his right to privacy, which has been restricted by virtue of his conviction. So ang kanyang right to privacy has been restricted. Bakit? By virtue of his conviction or how it affects his life, liberty, or security. And also, there's no allegation that the government agents were gathering, collecting, or storing data or info regarding his person, family, and home and correspondence. So there were no other allegations in support of the prayers. No? So hindi pwede. And citing the case of Alejano versus Kabuay, says there that a law is required before an executive officer could intrude on a citizen's privacy rights is a guarantee that is available only to the public at large, but not to persons who are detained or imprisoned. The right to privacy of those detained is subject to limitations as mentioned a while ago. By the very fact of their detention, again, we reiterate this ruling, this doctrine that pretrial detainees and convicted prisoners have, again, a diminished expectation of privacy rights. It went on to say that the right of a convicted national inmate to his or her privacy runs counter to the state interest of preserving order and security inside our prison systems. There is no longer now any reasonable expectation of privacy when one is being monitored and guarded at all hours of the day. And unless there's a compelling evidence that the public employee is engaged in a GCS of data or information on the convicted national inmate as committed unlawful act which threatened the life of the inmate, no, a petition for the writ of habeas corpus data cannot prosper. So thus, there's no compelling reason for this court to issue the writ. Okay, can we have a break?
Yes,
Let's have a break, please. Okay, sige. 10 minutes can already. Okay, let's be back. What I'm going to discuss is now on topic relating to names. So Rule 103, change of name. Okay, remember that. Rule 108, cancellation or correction of entries in the civil registry, which also includes name. And then we have our Republic Act 9048, which is also what? The Clerical Error Act involving names again. And the amendment to the Clerical Error Act, which is RA 10172. No? These are similar, but not identical. No? So anything that relates to first name, Ibato mo sa Clerical Error Act 9048, which is only an admin proceeding. So paano kung binago yung first name? It's not only clerical, but the name is from Juan de la Cruz to Mario. A complete change of name. That's also included in RA 9048. So yung the Clerical Error Act is not necessarily correct to say because it does not confine itself to rectification of errors in the given name or first name, but it includes also change of first name for grounds allowed or enumerated under RA 9048. What if what is involved is only a clerical error in the surname, not the first name? You go into Rule 108, cancellation or correction of entries in the civil registry. 108 is both summary for clerical errors and adversarial. When adversarial, when involves the status, nationality of a person or citizenship. No? Paano sir gusto kong baguhin ang name ko, to change my name because it's ridiculous, or it causes embarrassment, then you can do so under Rule 103. Rule 103, 108, they have different venue, 9048, then the amendment thereto is an admin proceeding. You don't file the case in court, but only in the local civil registry. So let's go to Rule 103. Okay. This is a change of name. So the question is, can somebody just change name? A class, this lecture, the contents is based on my book, Special Proceedings, A Foresight to the Bar Exam. So may 4 editions na to. The latest is 2020, no? Okay. Is change of name a matter of right? No. Because the court has had occasion to express the view that the state has an interest in the name borne by individuals and entities for purposes of what? Identification, and that a change of name is just a privilege and not a right. So that if it is not a right, if it is just a privilege, before a person can be authorized to change his name, given him either in his birth certificate or civil registry, he must be able to show PRC. Anong PRC? Proper or reasonable cause or any compelling reason. That's PRC. Proper or reasonable cause. C, compelling reason which may justify such change. If you cannot show that there is a PRC, the request, the petition should be denied. What are the valid grounds for change of name which are deemed as PRC? Deemed as, the touchstone for the grant of a change of name is that there be a proper and reasonable cause for which change is sought. To justify a request for change of name, petitioner must show not only some proper or compelling reason, therefore, but also that he will be prejudiced by the use of his true and official name. Among the grounds for change of name, which are deemed to be proper and reasonable or for compelling reason, number 1, when the name is ridiculous, dishonorable, or extremely difficult to write or pronounce, file ka under Rule 103. Paano sir kung ang first name is ridiculous, dishonorable, extremely difficult to write or pronounce? You file it under under 9048, the Clerical Error Act, which is only an administrative and not a judicial proceeding. Tandaan nyo, pag lahat ng first name, no? Any grounds, but you want to change your first name for any ground, whether it's clerical or change of name because it's dishonorable and it causes you, it's ridiculous, it causes embarrassment, by all means, you file it under 9048. But when it relates to your full name, then you file it under Rule 103. No? Second, when the change results as a legal consequence, as in legitimation. Third, when the change will avoid confusion. Fourth, when one has continuously used and been known since childhood by such Filipino name and was unaware of alien parentage. Also, a sincere desire to adopt a Filipino name to erase signs of former alienage, but it must be done in good faith and without prejudicing anybody. And lastly, when the surname causes, not the given name, but the surname causes embarrassment and there is no showing that the desired change of name was for a fraudulent purpose or for that a change of name will prejudice public interest. So, well, this is enunciated in the case of Santos versus Republic, penned by Justice Kagiwa. Probably there could be a question on this. Yeah? So, tandaan nyo to grounds under Rule 103 PRC, and those which are deemed as PRC are those proper and reasonable cause, are these. Name is ridiculous, dishonorable, or extremely difficult to write or pronounce. Second, when the name results as a legal consequence as in legitimation. C, when a change will avoid confusion. D, when one has continuously used and been known since childhood by a Filipino name and was unaware of alien parentage. E is a sincere desire to adopt a Filipino name to erase signs of former alienage. All in good faith and without prejudicing anybody. And lastly, F, when the surname causes embarrassment and there is no showing that the desired change of name was for a fraudulent purpose or that a change of name would prejudice public interest. I hope you're able to memorize that. Discuss the consequence of a grant to change of name. A mere change of name would not cause one's existing family relations. It will not create new family rights and duties where none exist before. No? It will not affect yung person's legal capacity, yung kanyang civil status or citizenship. What will be altered is the word or group of words by which he is identified and distinguished from the rest of his fellow men. A change of name granted by the court affects only the petitioners. Yun sa kanyang mga anak at asawa, a separate petition for change of name must be filed for his wife and children as well. How do you differentiate Rule 103 from Rule 108? No? Rule 103, petitions for change of name based on the foregoing jurisprudential grounds is a separate and distinct from that of 108. No? Change of name must not be confused with it. A change of one's name under Rule 103 can be granted only on grounds provided for by law. As mentioned kanina, yung PRC and those which we enumerated. In order to justify a request for a change of name, there must be a compelling, proper, and compelling reason. Okay? And proof that the person requesting will be prejudiced by the use of his official name. To assess the sufficiency of the grounds invoked, there must be an adversarial proceedings. In petitions for correction, especially dun sa mga summary lang, no, yung clerical error, spelling, typo errors, and other innocuous errors in the civil registry may be raised. Considering that the enumeration section 2, Rule 108 also includes changes of name, the correction of a patently misspelled name is covered by 108. Katulad, halimbawa ng Festin, instead of F, nakalagay P, patently misspelled name, then Rule 103. Suffices to say Not all alterations allowed in one's name are confined under Rule 103. No? Because again, refers to a complete name and Rule 103. No? In this case, nag-file siya ng Rule 103, but actually, the intent, you can discern the intent. No? The petition seeks to change his legitimacy to that of illegitimacy. The court said, no, Rule 103 will not suffice to grant respondent's supplication. In this case, it was granted by the court. The petition was granted by the court because Giovanni, the child, is entitled to change his name because in this peculiar situation, he was never recognized by his father, while his mother has always recognized him as her child. A change of name will erase the impression that he was ever recognized by his father. It is also to his best interest as it will facilitate his mother's intended petition to have him join her in the United States. So, mabait ang Supreme Court. This court will not stand in the way of the reunification of mother and the son. In this petition of Kalikasan Wang versus Cebu City Civil Registrar, this was denied, the petition was denied by the court. And the reason given is that in the case of Barr, said the court, the only reason advanced by petitioner for the dropping of his middle name is convenience. However, how such change of name would make his integration into the Singaporean society easier or convenient is not clearly established. Gusto niya kasi paalis yung middle name niya eh. That the continued use of his middle name would cause confusion and difficulty does not constitute proper and reasonable cause to drop it from his registered complete name. Denied. In latest case of Anacleto Alanis Balyaho Alias III versus the CA, the issue is this. The peculiar issue is whether a legitimate, not illegitimate child, yung legitimate child would want to use the surname of his mother. He doesn't want to use anymore the name of his father, the surname of his father, but the surname of his mother. And he is a legitimate child. So si Anacleto Balyahes filed a petition before the RTC to change his name. He was born to Mario Alanis and Armila Imelda Balyaho, and the name on his birth certificate was Anacleto Balyaho Alanis. However, he wished to remove his father's surname Alanis III and instead use his mother's maiden name Balyaho. That was the record since childhood. No? He also wished to change his first name from Anacleto to Abdul Hamid for the same reasons. And during this trial, petitioner testified that his parents separated when he was 5 years ago. His mother was the one who single-handedly raised him and his siblings. No? The RTC denied the petition, holding that petitioner failed to prove any grounds to warrant the change of name. Likewise, the CA affirmed the lower court's ruling. So the question is, a legitimate child entitled to use the surname of his or her mother as is his or her own surname? Ruling, yes, a legitimate child is entitled to use the surname of either parent as a last name, as embodied in Article 364 of the Civil Code in consonance with the state's declaration policy. What is the state's declared policy? To ensure the fundamental equality of women and men before the law. The RTC gravely erred when it held that legitimate children cannot use their mother's surnames. The point in view is Article 364 of the Civil Code. The provision states that legitimate children shall principally use the surname of the father. but the Supreme Court explained that principally does not mean exclusively. Hence, this gives ample room to incorporate into Article 364 the policy of the state ensuring the fundamental equality of women and men before the law and no discernible reason to ignore it. It went on to explain, with the Philippines as a state party to the Convention of Elimination of All Forms of Discrimination against Women, the non-discrimination against women emerging customary norm, and not least of all, in accordance with its constitutional duty ensuring gender equality, Congress enacted the Women in Development and Nation Building. So courts, like any other government departments and agencies, must ensure the fundamental equality of women and men before the law. And accordingly, where the text of a law allows for an interpretation that treats women and men more equally, that is the correct interpretation. Sabi ng Supreme Court, patriarchy becomes encoded in our culture when it is normalized. The more it pervades our culture, the more chances to infect this and future generations. So, very liberal ang interpretation ng Supreme Court. Now, let's go to Rule 103 specifically. Cancellation or correction of entries in the civil registry. So, under Rule 103 pala, where do you file it? You file it in the RTC where the petitioner resides. If you want to file a petition for a change of name, due to PRC, proper and reasonable cause, you file it where the petitioner resides. No problem with that. The RTC, jurisdiction is the RTC. Venue is where the petitioner resides. Rule 108 is entitled as cancellation or correction of entries in the civil registry. Who may file petition for cancellation or correction of entries in the civil registry? Any person, any interested person, in any act, event, or order or decree concerning the civil status of person which has been recorded in the civil register. Which court has jurisdiction on petitions filed under Rule 108? You file it in the RTC where the corresponding civil registry is located. Hindi where the petitioner resides. So if you want, halimbawa, I was born in Cebu, and then halimbawa nakalagay and it was recorded that my surname is Festin, a letter P, I have to go to Cebu, and file a case in the RTC therein, where the corresponding civil registry is located. Although I am now assuming that I am now living in Manila, but I have to go there. 103, walang problema, where the petitioner resides. Here, it's not the residence of the petitioner, but in the RTC where the corresponding civil registry is located. Balik ka kung saan ka pinanggaling. What entries are subject to cancellation or correction? Upon good and valid grounds. Walang problema. Well, the first one is birth, but it's not limited to birth. It includes lahat ng entries in the civil registry: marriages, deaths, legal separation, judgment of annulment of marriage, declaring marriage void from the beginning, legitimations, adoptions, naturalization, acknowledgement of natural children, election, laws or recovery of citizenship, civil interdiction, judicial determination affiliation, voluntary emancipation of minor, change of name. Is venue in cancellation or correction of entries in the civil registry under 103 jurisdictional? Meaning, pagka nagkamali ka ng venue, ma-dismiss ang kaso mo, hindi waivable. Sabi ng court, venue in Rule 108 is jurisdictional. In Fox versus Philippine Statistics Authority, we declared that Rule 108 pertains to a special proceeding. Hence, the specific provisions stated therein, particularly on venue, must be observed in order to vest the court with jurisdiction. So it's not purely venue, no, na it can be waived, no. It must be observed in order to vest the court with jurisdiction. In one case, sabi, in this case, sabi ng court, no, per the decision of the RTC, the report of marriage in this case can be found either in the DFA or in the of OCRG, that is in Pasay City or Quezon City respectively. And pursuant to Section 1, Rule 108, the petition must be filed in the RTC where the corresponding civil registry is located. However, sa final ng petitioner, nag-file siya sa RTC of Malolos City, Bulacan. Why? Because it is convenient for her kasi she's a resident of residing in San Miguel, Bulacan. Thus, venue was improperly laid. Moreover, the local civil registrar of Pasay was not impleaded. No, kailangan implead mo kasi yung civil registrar. No, the RTC of Malolos, Bulacan has no authority to order the civil registrar of Pasay or Quezon City to correct the civil status of petitioner. Question, is the proceeding under Rule 108 summary or adversarial? Makinig kayo dito na lumalabas sa bar to. Ang proceeding sa Rule 108 pwede maging summary or adversarial. No? Summary, kung ang correction is merely clerical. Of course, with the exception of first name. No? Kasi govern siya ng 9048. But where the rectification, no, affects civil status, citizenship, nationality of a party. No? Again, kung it affects civil status, citizenship, nationality of a person, it is deemed as substantial at hindi siya summary. And if it is substantial, it necessarily follows that the procedure is adversarial. So pag substantial, SA, adversarial. Pag summary, walang problema because it's only a correction. No? Okay, when you talk about clerical error, which is only summary in nature, walang problema. Is one which is visible to the eyes or obvious to the understanding, an error made by the clerk or transcriber, a mistake in the copying or writing, or some harmless or innocuous change such as correction of a name that is merely misspelled or a misstated statement of the occupation of the parties. So as I've said, halimbawa, Festin, instead of letter F, which is my family name, the first letter of my family name, nakalagay P, that's a clerical error only. But if it is substantial, yung sinabi ko, if it involves the civil status, citizenship, nationality, it is substantial and therefore, iba ang procedure. Appropriate adversary procedure. Ano yun? It is one having an opposing party. Meron ka ng opposing party dyan as distinguished from mere ex parte application. One in which the party seeking relief has given legal warning to the other party and afforded the latter an opportunity. Pag appropriate adversary proceeding, merong opportunity to contest it. No? Now, if it is substantial, adversarial, what does the rule require? It requires a strict compliance with the rules of court. No? When the petition involves substantial or controversial alterations. And this is done by availing the appropriate adversary proceeding. When a petition for cancellation or correction of an entry in the civil register involves substantial, controversial alterations, katulad ng sinabi ko, citizenship, legitimacy of paternity or filiation, legitimacy of marriage, kailangan strict compliance. Kailangan pag substantial, adversarial, strict compliance with the requirements of Rule 108. Strict compliance with Rule 108. Okay, what's the meaning of strict compliance? If it's substantial or adversarial. The fact that the notice of hearings at the court was published in a newspaper of general circulation and notice thereof was served upon the state will not change the nature of the proceeding taken. Kailangan mag-comply ka sa sections 4 and 5 ng Rule 108. A reading of sections 4 and 5, sections 4 and 5 of Rule 108 of the Rules of Court shows that the rules mandate 2 sets of notices. Kailangan 2 sets of notices to different potential oppositors. One given to the persons named in the petition. Nakalagay sa petition na yan. And another that are given to other persons who are not named in the petition but nonetheless may be considered interested or affected parties. Summons thereof must be served not for the purpose of vesting jurisdiction with the court, but to comply with the requirements of fair play and due process to afford the person concerned the opportunity to protect his interests if he so chooses. So, again, let's have a review. Pag clerical, walang problema. Misspelled, etc. Pag substantial, katulad ng legitimacy, illegitimacy, status, nationality, citizenship, no? Yan ay substantial change. So dapat adversarial. So ibig sabihin may potential oppositors. Dapat should comply with sections 4 and 5 of Rule 108. So ano yung 4 and 5 na yon? Section 4 refers to notice and publication. So walang problema. Publication, section 4. I-publish mo once a week for 3 consecutive weeks in the newspaper of general circulation in the province. Is that enough? No. The other notice could be given. Ito yung ininame mo doon sa petition mo. Under section 5, ang maging oppositor mo maaari ay ang civil registrar. But not only that, and any person having or claiming any interest under the entity. Pwedeng parents mo, no? Any person having or claiming any interest under the entity whose cancellation or correction is sought, no? That's 4 and 5. Publication and to implead, no, yung potential oppositors. Who are the potential oppositors under Section 5? The civil registrar or any person having or claiming interest under the entity. Pwedeng itanong sa bar exam kasi may latest case dito. Okay, sir, what if it is not published? No? Can there be, can publication cures one's failure to implead and notify interested parties? What I mentioned is just a general rule. Meron namang exceptions, no? Sabi ng court, this is a 2019 case. While there may be cases where the court held that the failure to implead and notify the affected interested parties may be cured by publication. Pero dapat, para to considered as an exception or cured by mere publication, ipakita mo na, number 1, earnest efforts were made by the petitioners in bringing to court all possible interested parties. You need to convince the court that no, you exerted earnest efforts, no, to bring all possible interested parties. Second, no, where the interested parties themselves initiated the corrections proceedings, no, where the interested parties themselves initiated the correction proceedings. And lastly, when there is no actual or presumptive awareness of the existence of interested parties. Hindi ko alam, hindi mo alam, you're not aware, no, na interested party pala yon. O meron pa ba lang ibang interested party? Or when a party is inadvertently left out, pwede yun as by way of an exception. But the general rule is that there should be publication and particular notices. Otherwise, the case is dismissible. Does publication in the newspaper of general circulation cure the defect of not impleading dispensable parties? As I've said, yun, okay, general rule. All persons who stand to be affected by substantial corrections of an entry in the civil registrar must be impleaded as indispensable parties. General rule, tandaan nyo. All persons who stand to be affected by substantial correction of an entry in the civil registrar must be impleaded as indispensable parties. Failure to do so renders all proceedings subsequent to the filing of the complaint, including the judgment, ineffectual. Okay? So, and this, sa kaso nito, hindi nag-fall ang exceptions which I mentioned kanina, yung earnest efforts, etc., or he's not aware. Kasi nakalagay dito, in this case, respondent had known from the start that she had two registered fathers. She knew her mother and all her siblings, yet she failed to implead them and offered no explanation therefore. Yun. In cases where publication may be deemed to cure one's failure to implead, no, special circumstances must be present to justify the non-inclusion of indispensable parties. These are the exception na publication cures the defect of not impleading the indispensable party. Again, let me repeat, earnest efforts were made by the petitioners in bringing to court all possible interested parties. The interested parties themselves initiated the correction proceedings. And lastly, there was no actual or presumptive awareness of the existence of the interested parties, or when the party was inadvertently left out. The court said that in this case, none of these exceptions are present here. So apply yung general rule. There was no proof that the indispensable parties who were not impleaded were aware of the petition, let alone the status of the proceedings. 2020 case to, no? When a petition for correction or cancellation or correction of an entry in the civil register involves substantial controversial alterations, no? Well, again, this is just a reiteration of what we discussed a while ago. There should be strict compliance with the requirements of Rule 108. Okay, ganun din ang sinasabi nito, no? Let me just read the doctrine. When a person for cancellation or correction of an entry in the civil registry involves substantial and controversial alterations, katulad ng citizenship, legitimacy of marriage, of paternity, strict compliance must be complied. If the entries in the civil registry could be corrected or changed through kasi kung hindi yan adversarial, kung summary yan, and then it will open the door to fraud or another mischief will be set open, and the consequence of which might be detrimental and far-reaching. So kaya kinakailangan ng strict compliance. Okay. Ito ang gusto nila ipakita kasi sa birth certificate nakalagay ang citizenship niya Chinese, ang parents niya Chinese. Ngayon gusto niyang baka makalusot, no? The respondent presented the identification certificates by the CID. Nakalagay doon ang parents niya Filipino, siya ay Filipino. Sabi ng court, surely their Chinese citizenship could not be converted to Filipino just because ang CID, no, or certain government agencies recognize them as such. And it quoted this, the exercise of the rights and privileges granted only to Filipinos is not conclusive proof of citizenship because a person may misrepresent himself to be a Filipino and thus enjoy the rights and privileges of citizens in this country. Hindi pa pwede yan. Question. Can the legitimacy and filiation of children be collaterally attacked? Can the legitimacy and filiation of children be collaterally attacked? Answer. No, it cannot be collaterally attacked by way of filing a petition for correction of entries in the certificate of live birth. In the case of Miller versus Miller, the court cited 2019 case. The court cited the case of Brasa versus the City Civil Registrar of Himamaylan City, in ruling that legitimacy and filiation can be questioned only in a direct action seasonably filed by the proper party and not through collateral attack. Moreover, impugning the legitimacy of a child is governed by Article 171 and not 108. Here, what is sought by petitioners is the correction of Joanne's surname in her birth certificate for Joanne to use her mother's surname, Espenida, instead of Miller, claiming that she was not an acknowledged illegitimate child of John. Sabi niya, hoy, wag mong gamitin yung Miller, ito ang gamitin mo. Hindi ka naman recognize. No? Sabi ng court, no, such is not a mere clerical change, not a simple matter of correcting a single letter in private respondent's surname due to misspelling. It will affect not only Joanne's identity, but her successional rights as well. So don't file it. You cannot impugn it by way of a collateral act filing under petition rule 108. No. Now, under Rule 108, anong consequence if there's failure to implead the civil registrar? The inescapable consequence of the failure to implead the civil registrar is that the RTC will not acquire jurisdiction over the case, or if the proceedings were conducted to render the same as nullity. No? The same as nullity. Such as in this case of Fox versus the Philippine Statistics Authority and the Office of the CELGEN, said the court, given that Rule 108 pertains to a special proceeding, the specific provision stated thereunder, particularly on venue, must be observed in order again to vest the court with jurisdiction. Hence, the inescapable consequence of the failure to implead the civil registrar is that the RTC will not acquire jurisdiction over the case, or if proceedings were conducted to render the same as nullity. Hindi nyo in-implead ang civil registrar, nullified ang proceedings. No? The court has no jurisdiction to try the case. The necessary consequence of the failure to implead the civil registrar as an indispensable party and to give notice by publication of the petition for correction of entry was concerned null and void for lack of jurisdiction, both as to the party as well as to the subject matter. So okay lang yan. So the court cannot be faulted. Refile mo na lang. Implead mo yung civil registrar. Well, we discussed this a while ago. 103, 108. 103, full name may be changed. 108, clerical and substantial errors may be corrected. 103, saan ipa-file ulit? Kung saan nakatirang petitioner. 108, no? File mo sa RTC where the corresponding civil registry is located. Sa 103, Solgen must be notified by the service of the copy of the petition. 108, civil registrar is made a party. 108, kailangan party siya in the petition as a respondent. Okay? Pero ang solged can also be notified. Rule 103, who is the petitioner? Any person who desires to change his name. 108, sino? Any person who has an interest in any act, event, order, or decree. So in both cases, kailangan mayroong publication. And in Rule 108, it is further required that the court shall cause reasonable notice to person's name in the petition. Yung sinabi ko under Section 4 and 5 of Rule 108. Huwag kalilimutan yan. In both cases, service of judgment shall be made upon the civil register concerned. Excuse me. Well, you are very, very familiar with this case, Dante Silverio, no? Should the petition for the correction or change of entry in one's birth certificate be granted by reason of sex change? No, because the statutory language of the old civil register law, it was enacted in the early 1990s and still remains unchanged. So the term sex as used then is something, it cannot be argued that the sex used in the early 1990s is something alterable through surgery or something that allows a post-operative male to female transsexual to be included in the category female. What about if a person is suffering from CAH, congenital adrenal hyperplasia? In this case, no, as opposed to that of the case of Silverio, in the case of kagandahan, allowed, no? Because the person is suffering from CAH. The person has biological characteristics of both male and female sexes. Principles laid down in kagandahan when the person is suffering from CAH or when the person is biologically or naturally intersex, the determining factor in his gender classification will be what the individual, having reached the age of majority with good reasons, thinks of his or her sex. Meaning to say, if he is suffering from CAH, no, intersex, pwede siyang mamili ng kanyang gender upon reaching the age of majority, 18 years old. Second, sexual development in cases of intersex persons makes the gender classification at birth inconclusive. So it is at maturity that gender of such persons like respondent is fixed. At any person is suffering from CAH, sabi ng court, belongs the human right to the pursuit of happiness and of health, and to him should belong the primordial choice of what courses of action to take along the path of his sexual development. So there is merit in a change of name with CAH. Question, may a petition for a recognition of a foreign judgment be made under Rule 108? Yes, no? Pagka recognition of a foreign judgment, pwede mo siyang under Rule 108, only have to prove the proof of fact of the judgment, no? In this case, sabi ng court, the recognition of the foreign divorce decree may be made in Rule 108 proceeding. Because yung Rule 108 is a special proceeding. It only seeks to establish a status right of a particular or a particular fact. And court said that Rule 108 of the Rules of Court can serve as the appropriate adversarial proceeding by which the applicability of the foreign judgment can be measured and tested in terms of jurisdictional infirmities. no want of notice to the party, collusion, fraud, or clear mistake of law or fact. In the case of Alaybar, this was asked in the bar exam. Somebody played a joke on her. She went abroad. She's single, and when she went back and tried to secure a Senomar certificate of no marriage, she was surprised and amazed that she was married to someone and she doesn't know this person. And there was no marriage that took place actually. So she filed under Rule 108. Now it was opposed on the contention that, teka muna, wag ka mag-file ng Rule 108. File ka ng petition for annulment, nullity of marriage. Court said, while the court maintains that Rule 108 cannot be availed of to determine the validity of marriage, the court cannot nullify the proceedings before the court. Pinagbigyan siya, no? And the punchline is this: respondent indeed sought not the nullification of marriage. Why? Paano ina-annul mo and there was no actual marriage to speak of, no? But the correction of the record of such record to reflect the truth as set forth by the evidence, or otherwise stated, in allowing the correction of the subject certificate of marriage by canceling the wife portion thereof, the trial court did not anyway declare marriage as void because actually there was no marriage to speak of. Hindi naman siya kinasal eh. Okay, malapit na tayo. Clerical Error Act 9048. No? Don't be deceived, don't be confused. This is not applicable merely to the clerical error of first name. Gaya ng sinabi ko, nag-a-apply din dito ang change of first name. Anything that relates sa first name. Anong issue sa first name, given name, iba to sa Clerical Error Act. You don't need a judge, just an admin body. What law governs the change of first name? The Public Act 9048. It governs the change of first name. It vests the power and authority to entertain petitions for change of first name. Change of first name to the city or municipal civil registrar. O kung sa abroad, pwede yan sa consul general. So under the law, jurisdiction over applications for change of first name is now primarily lodged with the aforementioned admin officers. Yan. What entries in the civil registrar 3 are subject to RA 9048? Sabi ng batas, no entry in a civil register shall be accepted, shall be changed or corrected without judicial order. Except, eto lang kung saan nag-a-apply ang 9048, clerical or typo errors of first name or change of first name or nickname. As I've said, i-file mo siya sa city or municipal civil registrar o kung nasa abroad siya before the Consul General. Is the Clerical Error Act limited to correction or clerical or typo errors? As I emphasized, no, it applies to change of first name or nickname. Does the Clerical Error Act apply to change of full name? No. If it's a full name, you file it under Rule 108. Where do you file it? As I've said, in the local civil register office of the city or municipality where the record being sought to be corrected or changed. But that's only number 1. Kung di feasible, kung lumipat na siya, petitioner has already migrated, then you file it in the local civil registrar of the place where the interested party is presently residing or domiciled, kung saan na siya nakatira. Okay? Kung siya ay nag-abroad, file mo na sa Philippine Consulate Office. Pwede rin. Okay, grounds for change of friend. So kanina, as I mentioned, pwedeng correction of first name or change of first name. Just like Rule 103, ridiculous, tainted with dishonor, extremely difficult to write, except that in Rule 103, it applies to complete name. Here, it only applies to first name. Or secondly, when the new first name or nickname has been habitually and continuously used by the petitioner, and he has been publicly known by the first name or nickname in the community. No, matagal niya nang ginagamit yan since childhood. Pwede yun. O thirdly, the change will avoid confusion. Kaya, will it apply to change nationality? No, it's not. No. So there is a change. There is an amendment to 9048, which is Republic Act 10172. So extending the application of the admin proceeding of 1948. No. So it's not limited to names, but now it applies to day and month, not the year. Day and month in the date of birth. Oh, remember that, not the year. Day and month in the date of birth, or sex of a person, when it is patently clear that there was clerical or typo error or mistake in the entry. Hindi pa pwedeng sex change. What entries cannot be changed? Nationality, age, yung year, status of the person. Kung ikaw ay magfa-file under this one, file ka ng early school records, no? To say that you have been continuously using that name. In case of change of gender, makinig kayo, meron tong case dito sa change of the certification. Di ba nire-require na yung petition ay kasama yung certification issued by an accredited government physician, attesting to the fact that the petitioner has not undergone sex change or sex transplant. Kinakailangan ba notaryado to? No. A certification ng pag-government physician, it's already a public instrument, public document. Hindi na kailangan niya inotarize pa. Okay. And publication for 2 consecutive weeks in a newspaper of general circulation. Okay. Rules of procedure on environmental cases. Writ of kalikasan, I'll just have to mention the latest case in 2021, Villar versus Altec Contractors Inc. Ito lang ang doctrine because kulang na tayong oras. The writ of kalikasan is principally predicated on an actual or threatened violation of the constitutional right to a balanced and healthful ecology, which involves environmental damage of a magnitude that transcends political and territorial boundaries. Now, if you're the party or you're the petitioner, anong dapat gawin mo? A party, therefore, who invokes the writ based on alleged defects or irregularities in the issuance of an ECC must not only allege and prove such defects or irregularities, pero dapat ilagay mo yung casual link, no? A reasonable connection between the defects o kaya irregularities in the issuance of an ECC and the actual or threatened violation of the constitutional right to a balanced and healthful ecology. Yun yung reasonable connection, no? Defects or irregularity in the issuance of an ECC at yung violation, actual or threatened, to violation of the constitutional right to healthful ecology. Otherwise, at the court, the petition should be dismissed outright and the action refiled before the proper forum with due regard to the doctrine of exhaustion of remedies. This must be so if you are to preserve the noble and laudable purposes of the writ against those who seek to abuse it. But in this case, unfortunately, petitioners, while kulang, no? While petitioners raise alleged irregularities in the issuance of the ECC, These are not material and necessary due to the nature of the proposed project. Therefore, no compelling reason was presented to warrant the intervention of the court. In one case, Temario versus Republic, yun, in-explain din yung Section 1, Rule 7, Part 3 of the Rules of Procedure for Environmental Cases. The writ is a remedy available to natural or juridical person, entity authorized by law, people's organization, non-governmental org, public interest group accredited by a registered with any government agency on behalf of persons whose constitutional right to a balanced and healthful ecology is violated or threatened with violation. No? By whom? By an unlawful act or omission by a public official or employee, or private individual or entity involving environmental damage of such magnitude, no, environmental damage of such magnitude as to prejudice the life, health, or property of inhabitants in 2 or more cities or provinces. A writ of kalikasan is aimed to provide a stronger protection of environmental rights in order to accord an effective and speedy remedy where the constitutional right to a healthful and balanced ecology is violated, and address any possible large-scale ecological threats. Okay. Necessarily, the person seeking the issuance of a writ of kalikasan must demonstrate that a particular law, rule, or regulation was or will be violated by the respondent. So, ito dapat alam nyo to. At least familiar kayo. Mas maganda, memorize nyo. No? A person seeking the issuance of a writ of warrant of kalikasan, ito dapat ang burden of proof. Dapat i-prove niya, number 1, the environmental rule or regulation violated or threatened to be transgressed. Secondly, respondent's act or omission complained of. Third, the environmental damage of such magnitude as would impair the life, property, or health of the inhabitants of 2 or more provinces or cities. Again, itong tatlo, the environmental law, rule, or regulation violated or threatened to be transgressed. Second, respondent's act or omission complained of. Third, yung effect, yung environmental damage of such magnitude as would impair the life, property, or health of the inhabitants of 2 or more provinces or cities. In this case, other than stating in general terms that the respondents violated such and such laws, the group or AGHAM did not propound on the specific acts or omissions committed by the respondent that would amount to a violation of the cited laws. It also did not adduce evidence that respondents are indeed guilty of any illegal act or omission violative of the rights of the people to a balanced and healthful ecology. Also, petition is not sufficient in form and substance as it failed to discharge the burden to prove the requirements for the issuance of a writ of kalikasan. So, kinakailangan memorize niyo yung sinabi ko na yun. In sum, there is no clear showing that respondents committed an act or omission violative of any environmental law which resulted or will result in environmental damage of such magnitude that will infringe the right of the people to a balanced and healthful ecology. Okay, so that ends my lecture. But itong tables, let me just emphasize yung comparisons, no? Baka kasi you might be confused, no, on how certain laws, writs are used, or if you're confused with jurisdictions. So let me just emphasize again the differences among 103, 108, 9048, 10172. No? 103 is a change of name. 108, cancellation or correction of entries in the civil registry. 9048, Clerical Error Act, and 10172, Amendment to the Clerical Error Act. Subject matter, change of full name, substantial. 108, clerical or substantial, no? Correction in civil registry. 9048, first name or given name, where there typo, pagka first name, typo errors, change of first name and nickname. Pag 10172, day and month at sex of a person, no? Who may file 103, a person desiring to change his name. 108, any interested person. Okay? 9048, any person having direct and personal interest in the correction thereof. 10172, the same as that of RA 9048. No? And remember this one, insofar as venue is concerned, Rule 103, the RTC of the province in which petitioner resides for 3 years prior to filing or in the city of Manila to the Juvenile and Justice Domestic Relations Act. 108, RTC of city or province where the corresponding civil registry is located. 9048, it's not filed in court. That's an admin proceeding. Okay. Please check on your mic, please. Mute your mic, everyone. 9048, you file it in the local civil registry where the record being sought to be corrected or changed is kept. Secondly, if he changed already his residence, you file it in the place where he's now presently residing. And thirdly, if he or she goes abroad in the Philippine consulate. The same also applies also to 10172. Okay? Yan. 103, remember that it's PRC, proper and reasonable cause, such as name is ridiculous, tainted with dishonor, and consequence of change of status. Third is necessity to avoid confusion. Fourth is continuously used and been known with such name, unaware of her alien parentage. And number 5, a sincere desire to adopt a Filipino name to erase signs of former alienage. 108, grounds, good and valid grounds. Okay. 9048, well, as discussed to you, if the name is first name is ridiculous, tainted with dishonor, or has been using it continuously since childhood, and third is to avoid confusion. Okay. 103, 108, they are judicial proceedings. 9048, 10172, admin proceeding. Okay. Insofar as publication, 103, 108, since this is a judicial proceeding, you at least once a week for 3 consecutive weeks. 9048, 10172, only 2 consecutive weeks, no? Remember who participates on the part of the government. 103, Solgen, or the proper provincial or city fiscal shall appear on behalf of the government. Rule 108, the civil registrar. 9048, 10172 is the civil registrar or the consul general. O, pag 103, saan mo ipa-file? File ka sa CA. 108, fa-file ka sa Court of Appeals then. 9048, hindi ka magfa-file sa CA. Mag-file ka with the civil registrar general. No, civil registrar general. In sa 94-8 at 10172. Okay, just a reminder again on jurisdiction and venue. Just love a review. Settlement of the estate, RTC, no, or MTC, depending upon the gross value of the estate. In case the decedent is a non-resident of Philippines at the time of death, venue lies in any province in which she had an estate. It's 2 million, it's the RTC, 2 million and less MTC. Escheat, RTC of province where the deceased last resided. In case he's a non-resident of the Philippines, venue lies in any province in which he had left his state. Parang the same as that. In settlement and escheat, almost the same. Guardianship, if it's guardianship over minors, no, is the family court where the minor resides, no. If the guardianship over incompetence, in the RTC where the incompetent resides, no. If they are abroad, then you file it in the family court where his property or any part thereof is situated, whether it's guardianship of minors or guardianship over incompetence. No, habeas corpus, no, for illegal confinement or detention, you can file it with the RTC, CA, SC, CA. RTC have concurrent jurisdiction. The writ of habeas corpus issued by the RTC, you know it, it's only limited, enforceable only within its judicial region. Pag habeas corpus for custody of minors, you file it to family courts of exclusive jurisdiction. The petition may be filed with the CA, SC, and if so granted, the writ shall be enforceable anywhere in the Philippines. Amparo, SC, CA, Sandigan, RTC. Kung sa RTC, there is a requirement, the place where the threat, act, or omission was committed or any of its elements occurred. If it's a habeas data, you can file it with the SC, CA, Sandigan Bayan when the action concerns public data, files of government. Now, if it with the RTC, the conditions are as follows: where the petitioner resides, or where respondent resides, or that which has jurisdiction over the place. The court which has, the RTC which has jurisdiction over the place where the data or information is gathered, no, collected or stored at the option of the petitioner. Okay, change of name under Rule 103. As I've said, madali lang ito, file it where the petitioner resides. Absentees are, hindi naman kanaan, it's not included. Cancellation or correction in the RTC where the corresponding civil registrar is located. Clerical Error Act, you don't file it in court again. Local Civil Registry, where the record is kept of not in the local civil registrar where is now presently residing, or in the Philippine Consulate Office. Distinctions, alam nyo na siguro ito. Okay. Habeas corpus just emphasize on deprivation of liberty or rightful custody of a person. Amparo, to any person whose right to life, liberty, or security is violated, no, threatened with violation with the participation of the government, no. Also, particularly extralegal killings and enforced disappearances. With so far as habeas data is concerned, the same also against private individual engaged in the gathering, collecting, or storing data or information. Okay. Venue in habeas corpus where the we have already said that a while ago. Okay na to. Remember the prohibited pleadings and motions in amparo and habeas data. Ayun, ang daming motion and other things that are prohibited. Okay. Ayan na yan. So of course, merong temporary, merong mga protection orders sa amparo. Temporary protection order, inspection order, production, witness protection order. Okay. I think okay na yan. Thank you. Keep safe and God bless. Again, rest in the love of the Lord. No, God has planted the dream in your hearts. You're so near now to your goal. Only one day to go. Give it all to God. No, and exercise your faith. There will be challenges every time that you have this noble dream. But remember to have faith. Faith is what? Faith is what? Is the substance of the things that you hope for. The evidence of things not yet seen. How will you know that you will become a lawyer? Deep inside your heart, you would know it's because of faith. And it's not based on a wishful thinking. And it's not based also on FATE, but on FAITH. So God has helped you throughout the ordeal. Keep close to God because He was the one who gave you that dream. Stay close to God. You will stay closer to your dream. Okay, God bless everyone.